My leaseholder hasn't paid their service charges. What can I do?
That's a really common question we get, and there's obviously an answer to that depending on whether or not we're talking about a commercial property or a residential property, but they often follow similar principles. I'm hoping that before you've asked me this question, you might have had an informal chat with whoever owes the service charges to see whether or not you can bottom out, a resolution to it before talking to lawyers. But generally speaking, the first step, if you have after you've kind of done that, or you've kind of figured out that this isn't going to go anywhere. It's a proper dispute that needs to be resolved. You've talked to your lawyers about it, and they're probably going to ask you for your lease. And we're going to look into this lease, and we're going to determine: have you done everything you needed to do to demand the service charges properly? Is there anything that we need to do extra in terms of making sure that you are actually owed those sums? Once we've kind of given that initial advice, the first step in almost all matters, regardless of if it's residential or commercial property, is we end up writing to whoever owes the service charges to effectively demand those sums again, and to see if we can resolve it through a letter, or if it's something where we need to kind of investigate more of a dispute. Perhaps they're challenging the amount, perhaps they're challenging whether or not actually they're falling due, or whether you have the right to recover those sums through the service charges. Once we kind of get past that stage, we end up deciding whether or not, well, is this something that maybe needs to be resolved by a court or tribunal? If you're looking at residential property service charges, there is a possibility, if you can't resolve it informally between each other, that you have to go to the tribunal and ask the tribunal to determine whether those sums should be charged to the leaseholder and what the amount is. So as a landlord or managing agent, you might very well be making that application yourself if you're hoping to recover them and you're taking the first steps. Or if you're a leaseholder, the leaseholder might, off their own bat, decide that the tribunal needs to get involved, and they can also do such an application. With a commercial property, it's a little bit different because you you may or may not really have the involvement of the tribunal, depending on what's going on, but it would be at that point a county court dispute, and you, as a landlord, would be the one progressing that matter and issuing the claim. So that's what we can do. That's the initial stages of how it usually runs. Of course, if there is, a discussion to be had at the earlier stages before it goes to tribunal or to the county court, it might be that you're doing some form of informal mediation, or if there's some other kind of alternative dispute resolution mechanism in the lease as well, it might be looking to invoke what that procedure is. But generally speaking, most leases kind of run along the lines of: we're writing a letter after we've reviewed what can be done. We're either talking about it or trying to resolve it before progressing it to formal court or tribunal proceedings.